Hello everyone, welcome to WOLA. We're very excited to have all of you here today after a long weekend. It's always difficult to get a good crowd, but obviously this is a very important and very good time to be talking about transitional justice in Colombia, given that the peace process is moving forward and more it appears as if we will have a agreement to end the conflict in the coming months. And of course, at the center of the process will be the victims and what will happen to them in terms of truth, justice, and reparations. It is also an issue of tremendous controversy and debate. It's also an issue that we've seen before in other conflicts around the world and in Latin America. So with that in mind, we thought it'd be a good time to bring in one of the foremost experts on transitional justice to WOLA to tell us a bit about what have been some of the lessons that we've learned in terms of transitional justice in the past 20 years in Latin America and elsewhere, and what could be some of the positive aspects and negative aspects and obstacles and everything that we can consider when we look at the Colombia situation. So with me today is Professor Jo Marie Burt. She's a senior fellow at WOLA. Jo Marie is also the director of the Latin American Studies program at George Mason. She has been working on human rights and political violence in Latin America since the mid-1980s, and she worked for the Peruvian Truth and Reconciliation Commission and has done countless amounts of research on transitional justice and how you try to get accountability, in particular, and how do you get perpetrators of egregious human rights violations to be held account for what they've done so that you get some truth and some justice for victims. Also, Jo Marie has been very closely following both what was the whole process with Fujimori and the whole process with Rios Montt in Guatemala. She served as an observer and has written several very important pieces on that experience, some of which I think we have out there. And with that, I think I could say that Jo Marie is basically the #1 person to talk to about these issues. And so what we thought we'd do is basically have a conversation to try to tease out some of the issues that are most relevant when we talk about what is happening in Colombia, but also where we are really with transitional justice in post-conflict situations in Latin America some 20, 30 years after these conflicts have actually ended. And I think that will very much enrich the Colombia discussion, but also enrich the global discussion on justice in general. So with that, I wanted to start, Jo Marie, by asking you to tell us a little bit about how are things different now in Latin America when you're trying to achieve transitional justice than they were 20 or 30 years ago when a lot of these conflicts ended?
Well, first of all, thanks for having me here and setting this up, Gimena. It's a pleasure to be here with all of you. I think it's important to talk about the changes that have happened in transitional justice, sort of the way we think about it and the way it's been carried out in practice over the past 20 or 30 years. When the military dictatorships of Latin America ended in the mid-1980s and into the early 1990s, that's sort of when the whole concept of transitional justice began to take shape, and different mechanisms were applied throughout the region. But back then, I think there was an underdevelopment, let's say, of international law and international humanitarian law regarding truth, justice, and reparation for victims. And so in many of the countries that transitioned from dictatorship to democracy in the 80s, Brazil, Uruguay, Argentina, Chile, for example, you saw a variety of approaches. In Brazil and Uruguay, for example, nothing was done from the part of the government. There was no truth commission, there were no investigations, there were no prosecutions, there were no reparations, until much later, at least in some cases. Argentina rather tried to, and successfully convicted the leaders of the dictatorship, but then after a series of military uprisings, as we all know, the amnesty laws were imposed, and even the military officers who'd been convicted were amnestied, or pardoned rather, and allowed to go free. So there's a next phase, starting with Chile, El Salvador, and I'll talk about South Africa a little bit because the experience of South Africa is very similar, where the paradigm becomes more or less a trade-off paradigm, where the main, I think, a concept was you couldn't necessarily have justice because of the nature of the transition. These were pacted transitions, or negotiated transitions in the case of El Salvador and South Africa. And so there was a limit to what could be achieved. So there was a trade-off. In fact, there was a book published in the mid-90s, I believe, titled Truth versus Justice. It was actually proposed as a dichotomy. But that started to give way with shifts in the international regime of human rights, where victims' rights to truth, justice, reparation, and guarantees of non-repetition became more consolidated, both in the inter-American system and in the international system of human rights protection. And that's changed the scenario. So we see that, for example, when Peru made its transition after 15 years of violence and a decade of authoritarianism, the situation there was much different than in the Southern Cone. In fact, even before the Truth Commission started its work in Peru, the Inter-American Court, in a ruling on a specific case, the case of Barrios Altos, the Inter-American Court said amnesty laws are null and void. They violate the American Convention on Civil and Political Rights, and they can't be maintained. And so, in fact, Peru didn't even have to deal with that question in a way. Right? It was resolved for it by the Inter-American Court. And so as the Truth Commission moved forward in its work, it came up with a very integral model of transitional justice. And I think this has been the model, at least normatively, that has become predominant among transitional justice practitioners. But as we know, in practice, there are still a number of legal and especially political obstacles to making this a reality. So we'll see cases like El Salvador and Brazil, that despite rulings like Barrios Altos and all kinds of international rules and regulations that determine that there cannot be amnesties for crimes against humanity, for war crimes, for torture, and so on, we see that those amnesty laws persist and that human rights prosecutions effectively are not moving forward. So there's a big gap in many places between the rhetoric or the norms of transitional justice and the practice. And that has everything, I think, to do with politics.
And where has it worked best in terms of trying to bridge that gap, and why has it worked best in those cases?
Well, it's kind of, these are contentious processes. I think that's the first thing to talk about. They're deeply contentious processes, and they're not at all linear. So, for example, Argentina is a great example of this. So, after you had the initial effort to prosecute the military, then the amnesty laws and over a decade of impunity, eventually, and in part because of the Barrios Altos ruling, but also because of the activism of human rights lawyers and because of changes within the judiciary, you had a new process where the Supreme Court, first local courts and then eventually the Supreme Court declared the amnesty laws unconstitutional. And once that happened, you began to see a new wave of criminal prosecutions for human rights perpetrators in Argentina. So you can see that there was an initial attempt to prosecute, then there were years of impunity, and then again a new wave of efforts to prosecute. So I think it's important to keep in mind the contentious and very political nature of these processes and the fact that it's not at all linear. And I think Argentina has in fact gone the furthest in, first of all, building a consensus, a societal consensus about what needs to happen for these criminal prosecutions. I think there's My sense is that there are very few people in Argentina, not that there's no one, but there are very few people in Argentina who will defend human rights abuses committed during the dictatorship and who challenge the legitimacy of the criminal prosecutions that are ongoing. And to date, over 400 or 500 members of the security forces have been successfully convicted of grave human rights abuses, and hundreds more are still in process. And this has been over more or less a 10-year period, more like 8 years. Chile has also seen some significant advances in efforts to criminally prosecute, but also, after many years of impunity and inability to prosecute, and there was a series of, and again, it's a lot of detail per country, but Peru's an interesting case in that initial gains made after the transition. First, you had a very, I think, successful truth commission that did a phenomenal job investigating the gamut of crimes that were committed in Peru, not only by state agents, but also by members of the Shining Path, and to a lesser extent the Tupac Amaru revolutionary movement. So they grappled not only with state abuses, which was the main issue in the Southern Cone, but also the abuses committed by non-state actors. So that was significant, and I think particularly relevant for the Colombia case. Once the Truth Commission finished its work, there was the big question about what to do with military who'd been implicated in, military and police officers implicated in human rights abuse. In the case of the Shining Path, because they had already been defeated, their leaders imprisoned in the early to mid-1990s, and a series of criminal prosecutions carried out, that was less of an issue. It wasn't really an issue of whether we should prosecute Shining Path. That had already happened. It was really a question of how and whether to prosecute the military. And following the recommendations of the Truth Commission, the Peruvian judiciary set up a special, the public ministry set up special prosecutorial and investigation units, and the judiciary set up special tribunals to prosecute specifically crimes of terrorism on the case of Shining Path, as well as crimes against humanity and human rights abuses. And that system worked particularly well for a while. We all know about the Fujimori trial, but there were a number of other criminal trials that took place and a number of other convictions, including of high-ranking military officers and high-ranking police officers that were carried out. But this generated a backlash. And what we're seeing today is the fruits of that backlash, where there's been a kind of a recomposition of very conservative political sectors, economic elites, and military to challenge, maybe not frontally. They tried to impose amnesty laws in 2008. They did not succeed. There was another attempt in 2000. In fact, the president signed a decree law that wasn't in effect an amnesty law, but that was overturned after domestic and international outcry. But in effect, what we see now is a dramatic backtracking in Peru, where not only, their trials continue, but the majority of cases are ending in acquittals of very questionable nature. And maybe some of you have seen in recent days, as has been in the news, the current Minister of the Interior, he was recently named, he himself is charged in an indictment that was handed down early last year in the case of a murder of a journalist from the weekly Caretas. And he's now the Minister of the Interior. So we see there's dramatic backtracking. So I think the thing to keep in mind is that these are highly and deeply contentious processes, particularly in countries that experience internal armed conflicts, which is the case obviously for Peru, Guatemala, El Salvador, and of course Colombia.
El Salvador is often mentioned as the conflict whose lessons can be learned for Colombia because of a lot of parallel situations, the duration of the conflict, the complexity of it, the huge cost they had, the huge cost they had in the society. What would you say about the Salvadorian experience as it relates to transitional justice? Do you think that some justice was achieved? What do you think could be learned from that experience for Colombia?
Well, obviously, justice in terms of criminal justice has absolutely not been achieved in El Salvador. There have been virtually no human rights prosecutions, save I think one or maybe two. Leonor here is here, and she's an expert on El Salvador, and she can maybe tell us, the one or two cases. But overall, there's been no criminal prosecutions in El Salvador. So justice in that sense has not been achieved at all. But what the Truth Commission did in El Salvador that I think is particularly interesting and relevant here was to name names. I mean, and they did so knowing specifically that the justice system in El Salvador was too weak and too corrupt to engage in any criminal prosecutions. And so naming names was seen by the Truth Commissioners as a way to provide some measure of justice for victims and to prevent those folks from continuing in public office. And in fact, there was some kind of a vetting process that went on after. And I think that's an important lesson to be learned for Colombia. And that was not necessarily followed in places like Guatemala and Peru. In fact, there was really no vetting in Guatemala or Peru. And I think we're seeing the fruits of that today. Where you have, government ministers, presidents, let's say it out loud, who have been implicated in grave violations of human rights. So I think vetting is an absolutely essential transitional justice mechanism that has been understudied in Latin America and not applied as extensively as it maybe should be. And I think that's one important lesson for Colombia that we should keep in mind.
One of the big issues in terms of Colombia has been the issue of responsibility, and particularly since you had the Declaration of Principles prior to the elections from both sides of the conflict, whereby the FARC said that it recognized the victims, and that was such a, although that has been criticized to what extent they've recognized the victims, but the fact that they've stated that they've recognized some of the victims at least has been seen as a big step forward towards accountability. To what extent did the different parties in the Central American conflicts as well as the Southern Cone accept that responsibility, would you say, to the liking of victims in those countries?
To varying degrees. In terms of the Southern Cone countries, obviously, they were pacted regimes, but they were pacts among elites. There was no involvement of victims groups in those pacted transitions. And in some places, there were formal apologies. The one that comes immediately to mind is the case of Argentina, where the current head of the army at that time apologized for the crimes committed by the Argentine army. And I think that's important. It's symbolically important, but it's usually not enough to satisfy the rights of victims, the needs of victims. In some places, the armed forces remain fairly unrepentant. I think that's the case in Uruguay. It's definitely the case in Brazil. It's almost undoubtedly the case in Peru. And in Guatemala as well. So I think that the willingness of all parties, in the case of Colombia, to address the issue of victims, and in this case, of course, we have victims on these different sides, is of fundamental importance in trying to develop a process in which victims play a central role would be, I think, quite revolutionary, really, for not only Colombia, but for transitional justice practice in general.
Well, the mechanism that's been announced in the Declaration of Principles in Colombia, in terms of how victims will be integrated, will include 4 public forums that are organized by the United Nations and the National University. The first one just started this past weekend in Villavicencio, and the others are happening this month and the next. And in those forums, the victims will be given an opportunity to talk about what they think would be truth, justice, and reparations in this case. That sounds very innovative. However, what would you say were some of the key specific actions that victims took during these different processes that helped move them forward in a way that was constructive? And in what ways do you think that the parties involved can help integrate the victims better
Right.
given what has happened there.
Well, I think it's important to remember, in many of these countries, clearly not all, but especially in places like Peru, Guatemala, El Salvador, and I would imagine also in Colombia, the survivors and the victims tend to come from the most excluded, historically excluded sectors of the population, the most marginalized sectors of the population. And so there's often a difficulty that these sectors face in terms of organizing and getting their message to a broader public. So the ability of, our ability to support them in that process, in bringing their message to a broader public, both domestically and internationally, I think is absolutely important. So that's one thing. I think one is building that societal consensus that as victims we have rights, and our nation has a duty, right, to make sure that our rights are respected and fulfilled. Victims or associations have done a number of things beyond sort of the appealing to public opinion. They've lobbied domestically, they've lobbied internationally, and they've taken cases abroad when needed, both to international courts and to the inter-American system. Obviously, Colombia's been doing this for quite a long time, and it will most likely continue to do so, and I think that's an absolutely critical element of the transitional justice story in Latin America. The inter-American system has played an utterly important role in helping consolidate a jurisprudence about victims' right and about the obligation of states to investigate, prosecute, and punish grave violations of human rights, on the one hand. But there's also the international courts. I'm just thinking about, in particular, El Salvador and Guatemala, which in the face of the inability of or the unwillingness of the domestic justice systems to move forward, victims groups have gone to Spain and other courts to try to have their cases heard there using universal jurisdiction. To lesser or greater success, but it's like a sounding board that can be very important symbolically, if not in terms of actually getting prosecutions happen. There's also this very interesting dynamic of when human rights perpetrators end up in the United States for whatever reason. And there have been a number of cases of efforts to extradite or have those folks sent back, in which U.S. government institutions and officials are involved, from the Department of Justice to the Department of Homeland Security, and human rights organizations like CJA have been very active in the Center for Justice and Accountability, have been very active in pushing those cases forward. And sometimes those kinds of cases can have a dramatic effect domestically. I'm thinking of the case of General, is it Monsanto in El Salvador? Montano, thank you, who was recently prosecuted here in the United States. So these extraterritorial tribunals can have kind of a ripple effect and may place pressure domestically. Then in the case of Colombia, I mean, it's probably the elephant in the room, but we have the ICC. I mean, many of the violations that were committed in Colombia happened after the ICC was created. Now, I don't know a whole lot about that, but I'll just raise it as an issue that I think is in the back of a lot of people's minds. If Colombia fails to prosecute effectively many of these abuses.
Well, the ICC question is a very interesting one, given that 3 different African leaders who have been basically investigated and indicted by the ICC are now trying to push legislation to make sure that if you are the head of state, you cannot be prosecuted by the ICC. So that also begs the question to how far do these mechanisms go to really achieve justice, but then at the same time, what sort of backlash can ensue that can actually make justice even more of an obstacle. Another big question about these transitional justice processes in Latin America, which is very relevant to Colombia, is the issue of the fact that most of the victims or good percentage of them are women. And there's been a lot of discussion of the Security Council resolution that basically mandates that women are involved in these processes and have a leading role in implementing them once they're designed. What can be learned about the processes in Latin America and South Africa in terms of how best integrate a gender focus in such processes in a way that really that is really seen on the ground?
Great. Well, I think it's important to say, first of all, that we've come quite a long way when it comes to gender and transitional justice. I mean, if we think about the truth commissions, the early truth commissions, they were essentially gender blind. I mean, it's not just that they didn't necessarily record abuses committed against women, but they did not have, in any sense of the word, a gender-based analysis. That began to change with the Guatemalan Truth Commission and especially the Peruvian Truth Commission. And I think that it will definitely be a central element of the Colombian Truth Commission when it is created, because it will most definitely be created. One thing I think to be learned is the need to talk about women not only as victims. I mean, obviously, there's a reality there that needs to be talked about. We all know that sexually based violence is a central element of the Colombian conflict, as it was in Peru and Guatemala. And that was seen very clearly in the Rios-Montt trial, where a dozen or so women quite valiantly came before the court and talked about the gang rapes by military to which they were subjected during the internal armed conflict. But I think it's important not only to talk about a gender perspective in terms of victimization and actual violations, but infuse the analysis with a gender perspective, how violence impacted women, how it impacted communities, how it impacted families. Because that kind of violence goes far beyond just the violence against the woman herself. I also think it's one of the things we learn from the cases in Latin America is that it's very difficult to prosecute these cases. The Truth Commission in Peru documented over 500 cases of sexual violence. To date, not a single one has been effectively prosecuted in Peru. Not a single one. There have been indictments. There have been, in fact, there are two cases, two very well-known cases. There are, in fact, two of the 47 cases that the Truth Commission recommended for prosecution. They have not moved forward. And it's not because there's not evidence. It's not because they don't know who's responsible. It's for a variety of different reasons, including a lack of a gender perspective within the public ministry. And I think there's a lot of pressure not to allow these cases to move forward from different political sectors. In Guatemala, like I said, in the case of the Rios-Montt trial, women who were victims of sexual violence were part of the case, but it's also important to remember that was used to demonstrate genocide. The sexual violence was not even one of the charges brought against Rios-Montt. So it's very difficult to prosecute those kinds of cases. So it'll be very interesting, I think, to see how Colombia manages to address this particular issue.
Another issue that has been of great concern has been the issue of balance in terms of the responsibilities of the state forces and the insurgents. Mm-hmm. How would you assess that balance in terms of the cases in Latin America? Where some of them were one-sided, how were those achieved, for example, in Peru?
Right. Well, Peru is very different in the sense that well before the transition occurred, the Shining Path had been defeated politically. Guzman, the head of the Shining Path, was arrested in 92. Several of the other high-ranking leaders were arrested between 92 and 95. And they were all prosecuted in the 90s. And whenever a new leader was arrested, they would be rapidly put on trial. One thing that is interesting is that the military court system that was used to prosecute those folks during the Fujimori period in the 90s were found to be lacking in due process guarantees by the Inter-American Court, and new trials were ordered to be held. Of course, this generated a huge uproar in Peru, a lot of fear that the terrorists were going to be let loose and so on and so forth. But that wasn't the case at all. New trials were held, including a new trial of Guzman and other top leaders of the Shining Path, and due process guarantees were respected, and they were in most cases they were effectively convicted again. So in the case of Peru, you didn't have a scenario in which you had both players sitting at the table negotiating. Right? When that's happened, which is the case of, I think in particular, El Salvador and South Africa, you've had very little forward movement on prosecutions. And that's a very worrisome thing for me in terms of thinking about Colombia. Because what's ended up happening in practice has been a sort of pact of impunity, explicit or implicit, because both sides, neither side, want their folks to be put on the docket, and so these arrangements are made, amnesty laws are passed, and there you have it. So that's what I'm afraid of in the case of Colombia. I think Peru is there are many lessons from Peru to be learned, but I don't think Peru is necessarily the most relevant case in that sense for Colombia. I think El Salvador and South Africa may be more relevant in what I think is a very worrisome way. So how do we ensure that in Colombia we don't get to a point where people are talking about different kinds of amnesty laws or different mechanisms that maybe aren't called amnesty laws but achieve the same thing, which is impunity? I think that would be the worst case scenario.
Well, hopefully what was stated by the parties of the conflict, that their pact is to not allow impunity to happen, so can become a reality. But I think that there's going to be a lot of need for outsiders, especially the international community, the United States, the Europeans, Norway, to guarantee that actually is implemented. So, what other lessons would you like to talk about before I open it up?
Well, I think the one thing I think it's interesting to think about is how this moment generates an opportunity for a country like Colombia to kind of reset or reboot the relationship between state and society. And the moment of transition is a unique opportunity for any any country to rebuild citizen trust in the state, in the judicial sector, and in the mechanisms of citizenship. I think what we see in some cases is there was very positive forward movement, and here I think Peru is a good example. There was very positive forward movement in taking advantage of that transitional moment between 2001 and 2001 rather, and not only investigating crimes of corruption but also human rights crimes, and going after the worst offenders and effectively putting those folks behind bars. And not only that, but also generating a reform process that reformed the institutions that generated both conflict and impunity. So from the military to the police to the justice sector, the impetus for reform, for institutional reform, was very strong. But, like we see in many places, there's also a lot of pushback. And so police reform went pretty far, but military reform really went nowhere. Judicial reform went pretty far, but in recent years, it's been rolled back. It's being rolled back. And what ends up happening is you end up having a backlash, as I said earlier, where these different groups who are interested in impunity, in returning to the status quo ante of impunity, regroup and develop a series of mechanisms. And they're different in different countries. I think in Guatemala, it's much more direct. Peru maybe is a little bit more subtle. But there are clear efforts to undo what was achieved at during those early years of transition and efforts of institutional reform. So how do we prevent that backlash? How do we take advantage of that moment of transition, which is a really unique opportunity, and help it consolidate? What I see has happened in many places, and I see this in Peru, is after several years, you get the Truth Commission, you get the Fujimori trial, there's huge international support during those crucial years, and then interest dies off, international community goes elsewhere, human rights groups, victims associations are absolutely starved of funding. There's a backlash, and now the human rights organizations and victim groups have very little resources to deal with the backlash. And the results are, we now have a Minister of the Interior who's accused in a grave case of human rights abuses. I mean, it's pretty dramatic. So I think keeping in mind this very unique opportunity is really, really important for all parties involved.
In terms of, before opening up, I have another question. In terms of implementing the mechanisms, obviously part of the obstacles have to do with political will and lack of political will, but in terms of the more technical aspect of it, how much has the strength or weakness of institutions and its capability to guarantee results quickly played a role? And given that Colombia is a country of some of the most progressive and wonderful laws on paper and wonderful mechanisms, usually for everything, but when it comes to reality, those mechanisms have a really hard time actually being implemented. What would you say is the best path forward to guarantee that institutions are strong enough to be able to guarantee initial results so that there's buy-in in the process?
That's a big question, and there's a lot of elements there, I think. I'm thinking in particular about, in Guatemala, the creation of the high-impact courts was very important. Well, there are two things that were very important in the ability of Guatemala to begin the process of investigating and prosecuting human rights abuses. One was the reforms that were carried out under, I'm forgetting the name of the Attorney General prior to Claudia Paz, and then during Claudia Paz's administration. Those reforms were essential in getting the public ministry to a place where they were actively investigating and moving forward with their cases. And then the high-impact courts, which were also within the sea of a very ineffective judicial system. There was an effort to create these high-impact courts to deal with big cases of organized crime, drug trafficking, but also human rights cases. And those were absolutely essential to moving these cases forward. But as we saw and see in Guatemala, those were vulnerable. So I think it's really important to figure out mechanisms to ensure the sustainability of the reforms, both in the public ministry and in the judiciary. Because without good prosecutors and without good judges, there will be no prosecutions, if we're talking strictly about criminal prosecutions. Obviously, there are other things that are important here, the creation of a truth commission, the creation of reparations programs, and the institutional reforms. But I think it's very important to think about how to sustain a reform process. Peru is another example where you had, upon recommendation of the Truth Commission, the creation of these special units, both within the public ministry and the judiciary, and they got a really good start. They had really good results initially, and then there was pressure, there was backlash, and there's been a gradual unraveling of those systems. We can't even call it a special human rights system anymore in Peru. And I could get into detail about that, but I think maybe I'll save that for later if people are interested.
Well, I would like to open it up for others to comment and ask questions. Please identify yourself when you speak.
My name is Ryan Peck. I'm a student at George Washington University. I wanted to ask panelists if there are any examples you could think of where Colombia of cases where the victims of human rights abuses were involved in illicit activities, and how that would complicate the situation of transitional justice.
Okay. Let's take a couple more. Anyone else?
Well, Peru is an obvious example of this. So, and I'm not actually in agreement with the way Peru resolved this question, but I'll tell you what they did. In terms of reparations, in Peru, the reparations law states explicitly that if you were a member of an armed organization, you are not eligible for reparations, regardless of whether you were a victim or not. I find this highly objectionable, because if I was a victim, I was a victim. But there are a whole series of caveats there, in terms of, if I'm a member of an armed organization and then I committed an act of blood, then maybe one could argue, and I believe that there's some precedent for this, that reparations could not be given, though one could think about using the reparation in that case to pay the reparations that person who committed a violation might owe to somebody else, to another victim. But if I'm a member of an armed organization and I committed no act of violence, I'm not sure why I wouldn't be entitled to a reparation. So that's a complicated issue when a victim is also a perpetrator. And there's some gray area there that Colombia is going to have to sort through on its own and come up with its own solution. But the way Peru did it in terms of the reparations law, I find a little bit objectionable. And I don't know that in Latin America it's dealt with as specifically as it was in the Peruvian case. But that's one model.
But the other issue that I think the question is getting at is the issue of drug trafficking. And I think in the case of Peru, at least initially, the former guerrillas were not accused of drug trafficking but terrorism, even though they may have been involved in both. So I don't know if you want to comment on that. And then my question to Gimena would be, so far in the, with what's come out in the peace process, how is this issue being dealt with in Peru, where you have, a guerrilla organization that's also been, deeply involved in the drug trade?
Oh, I took illicit activities to mean, yeah, I see what you're saying. I took it to mean other acts of violence. But no, I think you're right. In the Peruvian case, there are some members of Shining Path who've been convicted of, Artemio was recently convicted of this more recently. But in general, it's not been. The convictions have been based on their acts of violence, not on any involvement in drug trafficking or anything of the sort. I don't know of any other cases in Latin America that deal with this issue.
The Colombia process is the first one where you've actually had on an agenda item on illicit activities, drug trafficking, and how that will be addressed will be very interesting, because we see the interconnectivity of two different international legal regimes basically at clash with each other. So it will be very interesting to see how Colombia resolves that question. It will be central to guaranteeing this.
Hi, I'm a student at UC Berkeley, and I was interested to know a little bit more, going back to the women issue and how that relates to justice. Often during this sort of violent situation, women are victims of sexual abuse, and that can lead to a variety of things. I think you mentioned issues with family, also sexually transmitted diseases, perhaps unwanted pregnancies, and the issues are very widespread for peacekeeping, I think, in general, to have that security for women. So is the justice system obliged to rule on this? What is kind of the scope of their authority over these negative, consequences for women? And then do legislators want to work with the justice system? Do they have that obligation to effect change? And if not, why not? And how can we address that?
It's really an incredibly complicated issue. What I've observed in the Peruvian case in particular is that particularly the issue of pregnancy by rape becomes a key sticking point for justice processes to move forward. There's one case This is one of the two Truth Commission cases, one of the two commissions of rape within the 47 cases the Truth Commission recommended be prosecuted, in which a woman was arrested upon entering the university. She was going to enroll, she was arrested, she was believed to be a member of the Shining Path, which she was not, and she was gang raped by several, I think it was 8 soldiers. And she was impregnated. She was in jail for 8 or so years. When she was finally released, her case went before the Truth Commission. They recommended prosecution. The case moved forward. And the NGO who was representing her said, well, we actually have the perfect evidence, which is your daughter. So we should run a DNA test on your daughter, and we'll be able to determine without a shred of doubt who's responsible. And she said, because that will only mean a conviction against one of my rapists. I want them all prosecuted. And it's he said, she said. It's very difficult to demonstrate this in a court of law, and the case has been utterly stalemated since then. In another case, which involves, it was a military base in the community of Mantaybilca in Huancavelica, in which the Shining Path had been active in the community. Military came, Shining Path fled. The military essentially either killed the men in the community or forced them to join their ranks. And the women were basically turned into the military sexual slaves for almost a decade. And there were a number of children born as a result of this scenario. And again, it's another case that does not move forward because the women feel that they have inadequate protection. They don't, there's an incredible stigmatism. I mean, there's stigmatism in general in rape cases here in the United States. Imagine in indigenous communities, it's tenfold, where women have no guarantees that their identities will be protected, and they often don't share the information with their current spouses. There's a case that I observed firsthand. It wasn't a case of sexual violence. It was a case of torture, forced disappearance, and execution are the charges brought against several leading military officers. This is also in Peru. But there were a couple of cases of women survivors of prison and torture who were also raped while they were prisoners, and they were called to testify. The NGO that represents these women promised them that their identities would be protected because they didn't want their families and especially their spouses to know. The prosecutor in the case decided that they needed to talk directly with one of the victims. They went to her home shortly before she was to testify and knocked on her door very early in the morning and said, "We're from the public ministry, we'd like to speak with you." And she had been told by the NGO, "Don't speak with anybody, this is for your protection." So she said, "No, I'm not able to talk." And so the person from the public ministry said, "Well, I'm from the public ministry, I'm here to talk about your testimony about your rape." And her husband and her family were right there. Her husband beat her and then left her, and she refused to testify. So this is the kind of scenario that a judicial system that's not prepared, I'm not saying unwilling, it's just not prepared to deal with the kind of protection and guarantees that women require. It's just not set up this way. And so I think there's a lot of work that needs to be done all over the region to make judicial operators more sensitive, more aware, and create mechanisms that actually protect women, because otherwise they are not going to speak out. The Guatemala is another scenario where these 10 women, they were initially had been told that they could give their testimony in private during the Rio Smoke trial, and then that was rescinded. They had to speak publicly. And they debated about whether to do so, and they decided that they would go ahead. And that's why you may have seen it. When many women, when they went before the judge, they covered their faces with their scarves or their trajes, but they spoke in open court. Well, it's not difficult to identify these women. And there are reprisals and there are threats and intimidations in the communities, and there's no mechanisms virtually set up to protect these folks. So it goes beyond just the women, but I think the case of women and sexual violence requires a very specific set of protections that are grossly lacking in the region. There's a third thing that's come up in Argentina, which is in places like Argentina and Uruguay, where women who were themselves prisoners and were raped while in prison, but who were also victims in the sense that their family members, their husbands, their children, whatever, were disappeared, and they were more focused on the disappearance of their loved one than their own rape. But once their cases come to trial and they begin speaking about what happened to them, they actually talk about having been raped. And the judges literally don't know what to do with this. And they said, well, why? They didn't believe them. Why didn't you talk about this before? Why are you just bringing this up now, 20, 30 years later? And so the human rights groups that work with victims there have had to generate discussions within the judicial system to help both prosecutors and judges understand why a woman might not speak about having been raped in a particular circumstance, and that they need to take those claims seriously. And since there's been, I think, 2 convictions in Argentina, I think it's one of the very few places where in a transitional justice context there have been convictions for the crime of sexual violence against women.
It's very complex.
Very,
Let's
very
take last round. Let's start here and we can go back that way. So please identify yourself.
Hi, I'm Leonora Arteaga from the Process of Law Foundation, and I want to ask Jo Marie to make a comment on what lessons could be learned from the Peruvian and Guatemalan experience to Colombia how to work in a collaborative way between the NGOs and the victims groups and the judges and prosecutors. Is it possible without substituting the state's duties, without doing the work that has to be done by judges?
Okay, let's take the man in the back. Yes.
My name is Pat Patterson from National Defense University. How do you convince the Colombian military and the police forces, who have a lot to lose, to collaborate, cooperate, provide evidence, that kind of information, especially after they see what's happened in countries like Argentina to their colleagues down there?
Diane Perlman, School for Conflict Analysis and Resolution at George Mason. Just to decide before my question, if anyone's seen the movie Invisible War, this is also in the U.S. military, problems with rape and impunity, so I'd say tenfold, morefold there. But I noticed you talked about truth commission, but not truth and reconciliation processes and not restorative justice. And I think they're probably a very small percentage of people who may have remorse, who might want to apologize. I'm not saying it's a majority, but say as an alternative between impunity and punishment, like a third track of repair, people who are willing to redeem themselves or to earn some kind of forgiveness or to try to make up for what they might have done.
And then,
my name is Ron Robinson. One comment and a question. First, the comment. You talked about infusing a gender view in war and conflict. First of all, gender-based violence should probably be more called sexual violence, because both men and women, boys and girls, are victims as well as perpetrators of that violence. USIP has an outstanding training program called Men, Women in War and Peace. For anyone who's interested in that, you could go on and Google it. Second, talking about prosecutors and prosecution, you also need evidence. Talking about the gathering of evidence when the crimes are still fresh. I know that Johns Hopkins University School of Public Health has a program where they are actually have vetted a sexual violence screening tool that allows people to be screened for sexual violence without asking them directly and not stigmatizing them. Dr. Alexander Vu is the MD, PhD who's in charge of that. I wanted to know, they use it specifically for, to drive programming, to provide counseling as well as medical assistance for victims of sexual violence. But it seems to me like a tool like that could be used as well to gather evidence. I wanted to know if there are any good examples of evidence gathering by either UN or non-governmental organizations that protect the victims' rights, don't stigmatize them in the community, but also gather evidence even if prosecution is for the future.
And I'm going to take one last one there and then let you
I
answer.
was actually going to touch on that briefly. If there's any cases of women perpetrating sexual violence and how that's dealt with, whether it's dealt with other, their male counterparts, or it's a totally different issue if you want to put a gender lens on it, but just how that is dealt with.
Let me start with that one because I think that might be the easiest one for me to answer. I know of no cases, personally, of women engaged in sexual violence. That's not to say it doesn't exist. I know of none in the cases I have looked at. Do you know of any in Colombia or in Africa?
Republic of Congo, Rwanda, there are a wide variety of
That's not to say there aren't women perpetrators of human rights abuses, because that I am. There are several cases of that in Peru and elsewhere. But your point about it being called sexual violence and not gender violence, I think, is absolutely right on, because the Truth Commission documented in Peru, I think it was 11 cases of violence against men, but there are obviously many others that are never reported. Evidence is absolutely essential to any criminal process, obviously. The problem in many of these cases that I've studied is that the crimes happened 20 or 30 years ago. And so you need to find other ways to construct evidence. Circumstantial evidence is crucial in these kinds of cases. Direct evidence is also often very difficult to come by, especially in sexual violence cases, I think. But in general, NGOs play an essential role in helping document, in documenting the abuses and providing evidence. Government official documents are also essential, and oftentimes these are obtained, illicitly. They're leaked, and then they become used in criminal prosecutions. But many of these countries have access to information laws that specifically prohibit the state from withholding or declaring as secret or classified documents that relate to human rights abuses. And yet the practice is that the states don't share those documents, which in many cases result in Peru. Over half of the criminal complaints in human rights abuses have been archived because there's no way to demonstrate who the perpetrators are, because the state won't share information, the military won't share information about who was in what military base in what year. That could help, clarify many of these cases. So that's a real problem that we have, around the region. In some places, Argentina and Brazil very recently have opened the archives. They may be not very well organized, but that's a task for civil society, I think, at some point to help organize those archives.
Yeah, and just to add that in terms of Colombia, it will be essential, the U.S. basically giving the archival information and free access to that information the past 20 years.
That's essential. In the case of Guatemala, the United States, Bill Clinton ordered an agency-wide review, and all documents were released to Guatemala. And that greatly facilitated the work of the Commission for Historical Clarification. In Peru, under the George Bush administration, it was quite different. We asked for an agency-wide review. It was not granted. And only some agencies, therefore, released documents. The State Department released quite a few documents, but the CIA, the DEA, the DOD,
It was what we got through FOIA requests.
that's it. So something like that could be, one very specific thing that you could ask the United States government to do that would be extraordinarily helpful to investigators. But both in terms of, helping us understand what happened, the truth, but also in terms of prosecutions. In terms of the collaboration between NGOs and victims and judges and prosecutors, it's proven to be absolutely essential in the cases that I've looked at. NGOs and victims groups in particular have in many ways, almost substituted the work of the public prosecutor's office. I mean, in many cases, they're the ones doing the evidence gathering, gathering testimony of victims, obtaining documents, official documents. And sometimes the relationship is a pleasant one, and sometimes it's a confrontational one. But it obviously helps when it's collaborative. Because I think the NGOs do play such an important role. And the weakness of the public ministry in terms of its investigative capacity, its institutional capacity, I think that comes into play. That's really, really important that happen. How do I convince the Colombian military to collaborate?
Some ideas.
I'm going to let her answer that one. I mean, absolutely. I think that in general, the militaries of Latin America don't want to collaborate. They want to prevent what's happened to the Argentine military, or some of the Peruvian military, or some of the Guatemalan military from happening. But I think it's a short-sighted view. It's protecting a handful of people who are responsible for the gravest violations of human rights at the expense of the reputation and solid reform of the military as an institution. And you have to think long-term. You have to think about the long-term construction of a military that's democratic, that respects the rule of law, and only by vetting and meting out sanctions against those who engage in some of the worst abuses, I think will help achieve that. So I think in the end, it's in the military's interest. Maybe not in the interest of individual members of the military, but that's why I think vetting is so important. If you get those folks out of the picture, if that's possible, then you create a space to focus on the institution, not on the individuals. Otherwise, you're going to have ministers of the interior in Colombia who were former human rights abusers, maybe even presidents.
Well, I think on that issue,
sure.
that there are two things. One is that the role of the military in Colombia is going to have to shift and change quite a bit through this process. I think that's where the United States can play a huge role, given the long history of human rights conditions, vetting of units financed by U.S. funding and so forth. The U.S. could really help in that regard to look at the long-term view and to see what would a military look like in a non-conflict society and what roles they could play. So rather than seeing it as losing out, so to speak, to be transitioning to a different role, and if they want to be part of that role and a constructive player in that role, they need to reconcile it. For reconciliation, you need to give information and so forth. So I think that the U.S. is actually going to be essential in trying to move that thinking forward in the case of Colombia.
And then the last question by my colleague from Church Mason about restorative justice. The Latin American experience has been, historically, that to talk about reconciliation is almost the equivalent of impunity. So reconciliation, restorative justice is almost a dirty word in Latin America. I think what can be useful is to think about it in a slightly different way. There are cases, many cases, of soldiers and even military officers who are willing to come forward and speak about what they did. Sometimes they're repentant and then other times they're not repentant. But they're willing to tell what they know. What you need to do is create a framework to allow that to happen and make it mean something. If someone sits across from me and says, "I killed your mother, I'm really sorry," that really doesn't help me. But if I say, "I'm sorry," I don't even have to say I'm sorry, but I killed your mother and this is what happened, and this is who ordered me to do it. And I don't care if I offer that person some benefits in exchange for that. As long as that person is helping me obtain information that will help me go after the most responsible, people who are most responsible for that crime, or for those series of crimes. I think then it can be very useful. So in Peru, you had, for example, the law of effective collaboration is my literal translation of it. I'm not sure if that's the way we would actually translate it to English. But this law allowed the public prosecutor's office to obtain testimony from perpetrators and offer them a plea bargain, lowering their sentence as long as they provided concrete and effective information that helped, first of all, clarify the organizational structure of the different paramilitary or military units responsible for gross violations of human rights, and identifying leadership structures. So in that context, I'm thinking, I want people to be able to apologize or speak about what they did. But I think it has to happen within a framework. Just sitting at a table saying, oh, I'm really sorry, there's a space for that. But I think it's much more helpful for a true reconciliation process to frame it within such a way that it actually helps I'm trying to think of the right word, disarticulate the illegal structures that exist within the military and within other bodies, right? Whether they're paramilitary structures or whatnot. So that would be my answer to that.
Well, we're going to have to close because we've gone over time, but I think that this conversation definitely has highlighted the fact that we've opened up a Pandora's box of multiple issues that need to be discussed and debated, and that we can learn a lot from what has already happened to make sure that this process, at least as it moves forward, has the most adequate information, the most interesting information to be able to feed it. In the end, it will be its own process, and it is a negotiation, so we'll have to see how that plays out. The Colombian society is going to determine to what extent that will be implemented and how. But definitely, we will continue these conversations. We'll have a group of victims, including victims of the FARC, coming here in about 2 weeks, 3 weeks. We'll invite all of you back again, and we'll be bringing more experts to come and help feed this process so that we can help from the outside, give some insight that might be useful for achieving true justice and reparation. So thank you so much, Jo Marie, and everybody.